Microphone is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number CV23-0763, Brown et al. Versus Old Fashioned et al. Council, we're recording and live streaming the argument, so please identify yourselves and who you represent at the beginning of your argument. Each of you will have 20 minutes, but you're not obligated to use all your time. Appellees, I don't know if you're splitting time, but I'll leave that to you. Appellant's counsel is responsible for watching the clock to reserve a portion of the time for rebuttal, if desired. And also, please keep in mind, we've read the briefs, we've studied the record, and we've discussed the case in conference. With that, Mr. Abney, you may proceed.
May it please the court. My name is David Abney. I'm here representing the plaintiffs' appellants. I'm here with Jeff Miller, my colleague and co-counsel. As always, it's a pleasure and honor to be here. I usually have something interesting to say as an icebreaker, but I'm out of material today. Other than I saw Caitlin Clark play over the weekend and come from behind in a fantastic game, and I thought to myself, boy, you should never give up. So I'm not giving up on this. The difficulty is, I think, reasonable diligence, and who gets to decide if someone has been reasonably diligent in ferreting out the facts, in this case, facts concerning a possible dram shop action. And as I was discussing with my colleague, we could be holding a great big bag of nothing. I mean, if we do get to go forward on the dram shop action, we don't know for sure what we'll find as far as evidence. Any videotapes that may have been made, video recordings may have been destroyed by now. People who worked at the bars may have gone or have conveniently vacuous memories, and we may not be able to tie anything in. But still, the clients should have an opportunity to proceed and do what they can with the cause of action. And that goes.
The motion to dismiss that was filed did not include any material outside the pleadings.
Correct.
And the response did not include any material outside the pleadings. So the judge was required to limit her consideration to the allegations in the amended complaint, right?
Correct, Your Honor.
And so there was nothing in the amended complaint that would indicate any basis for tolling the statute of limitations.
No, and that's why material was eventually got into the record as the case went forward and morphed into what really became a summary judgment proceeding where there was material presented.
Okay, well, but that didn't happen until after the motion to dismiss was granted. The motion to dismiss was granted on August 15th. A week later, the motion for reconsideration was filed, but the court never set aside the August 15th dismissal order, right?
No, it did not. But in so many words, it certainly did not. But in effect, it did. It considered the motion for consideration, say, I'm going to think about these things. I'm going to consider the materials that you have provided, and then went forward and based on that said, oh, no, I'm not going to do this reconsideration. But it took all those matters into account, and that was one of the issues was to whether the grant of the motion for reconsideration was an abuse of discretion, and we submit that it was.
Well, correct me if I'm wrong, it sounds like you're saying that simply by filing the motion for reconsideration that vacated the dismissal order and required the court to start all over.
No.
Okay, then what's incorrect about what I just said?
Well, judges don't have to do much of anything with motions for reconsideration except to say I'm not going to listen, but if they do listen, if they do say to the other side, okay, file a response, let's have a reply, let's have an oral argument, let's discuss all this, then they really have taken it under consideration, and at that point, if they decide to deny the motion for reconsideration, you can say, okay, we think you've abused discretion in doing that, because there was enough here that if it went to reasonable jurors, they could say, okay, you were reasonably diligent. Now, whether they would or not, we don't know, but there are certain things that really ought to go to the jury. Whenever you start using the word reasonable, alarm bells go off in my mind. You're really talking about, well, what would jurors think about this? And if you go to the jury and say, okay, we knew that this person had too much alcohol. I mean, that's pretty obvious. He says he had no memory of where he got it. So maybe there's some records that would show that he was at a bar, a saloon, a restaurant or something, and maybe he drank alcohol there, although the credit card bills are ambiguous, to put it mildly. What did he buy? Don't know. Could have been buying Kool-Aid and Diet Coke and potato chips, and we don't know what he bought.
So
But
you're
assuming that
saying
there's-
by submitting these extra pleading materials with the motion for reconsideration, Rule 12D kicked in to convert the motion to a motion for summary judgment.
In effect, yes, in effect, that's what would have happened. 56D, something like that, yeah.
Okay, so what was it? What was the motion that was being converted to one for summary judgment?
It would have been the motion to dismiss, which is, and you're reconsidering it, you're opening the door again if you're actually going to reconsider something, aren't you?
Okay, but the motion to
Oh, I didn't mean to
dismiss
ask a question, I'm sorry.
had
Ron.
already been ruled on.
Well, yeah, but if you're gonna actually reconsider something on the merits, you are effectively de facto reopening it. You are considering it anew, afresh, and reaching a determination. Now, whether that's a abuse of discretion or not is
Isn't
the
it a
problem.
well-established principle that when material extraneous to the pleadings is unnecessary to the final outcome, a motion to dismiss is not converted to a motion for summary judgment?
But these materials are important to the outcome, are they not? I mean, what they were doing, what they basically did, the thrust of what they did is they went to the council, well, other than considering the investigation by the insurance company and the investigation by the state, and they reviewed all those materials, they went to the council for El Dorado Mucaj, wonderful name. I don't know where that came from, Anyway, so they went to El Dorado Mucaj's counsel and said, what do you got? Can you give us information? And he says, my client's taking the fifth. So, I mean, they're stopped there. The judge says, well, why don't you go and subpoena? Or why don't you subpoena him? Why don't you get a motion to compel or discovery request? What good's that going to do? You have to say, well, would reasonable jurors say, well, if his lawyer says, I'm not going to give you anything, what's the point of doing all these other things aimed at getting information from him?
Wouldn't the point just be that you're showing a good faith effort to try to get the information? Even if it leads nowhere, it's at least showing that you're trying.
Well, it's sort of like the charge of the light brigade. What's the point? Well, it's a bad example. They did succeed in the charge, but it's something that really should produce nothing. If a lawyer representing a client says to me, he's going to take the fifth, why do I assume the lawyer's a liar and go ahead and subpoena him anyway or do discovery requests against him anyway? I think I have the right to assume as an officer of the court, if the lawyer says he's going to plead the fifth and you're not going to get anything, then he's going to plead the fifth and we're not going to get anything. So if we subpoena him and his records, we're not going to get anything from him. It would be a futile act.
Was the defendant the only one that knew anything about
No.
bars?
And there's
Or
an interesting...
or the credit card?
Now, there's an interesting point. And I think there's an interesting point that reasonable jurors could disagree about. How far do you have to go? How far do you have to be creative? What do you have to do? So if you go, suppose you say, okay, go to the hotel and subpoena him, see if he paid cash or credit card. If he credit card, try to get information through the credit card company, or go to the rental car company and try to get information through the rental car company on the credit card, and then subpoena the credit card company. But wouldn't reasonable jurors say, well, hold on here. We have a right to find out what protocols the credit card company has in place. Does it have protocols where if it receives a subpoena or other court documents saying, give us some records, that it says, we're not going to do that. Immediately, we have to inform our customer, and then our customer has a right to come in and say, to oppose your subpoena. That's happened to me many times. And if
We'll
so,
never know the answers to those questions because it wasn't done here.
exactly, and that is a question really for the jury to decide. What if you had done this?
So
What
you're
would have
saying
happened?
Your client didn't need to do anything then?
No.
Other than just say they pled the fifth. All right, the defendant keeps pleading the fifth.
Right.
That's all we have to show.
And they kept on after. It wasn't just one request. It was over and over. And eventually, when the time came where the fifth didn't matter anymore, then they got the information that they needed, and actually they were given the records, the
What do you
scanty
mean they got
records.
the information they needed? What information?
The credit card, a couple credit card statements. That's what they got, or a credit card statement. They got it was given to them by Mukaj's counsel.
This is like 2 years
It was down the road.
I mean,
Right.
after the complaint should have been
Right.
filed.
And was that reasonable diligence? I sense skepticism on the part of the court. But reasonable jurors could say, well, hold on here. This is not as simple as it might seem at first glance. What would have happened if they had contacted a credit card company? We have a right to find that out as jurors before we weigh whether there has and decide on whether there has been reasonable diligence.
But let's go back to your conversation with, or exchange with Judge Kiley. Why, I mean, your client chose not to provide these 18 exhibits until the motion for reconsideration. I mean, why? I mean, you don't need to answer that. I mean, that's the fact. The fact is, it didn't respond to the motion to dismiss with these documents that are, I mean, apparently relevant, right? The 18 documents, are they relevant or helpful or seem?
To which?
But why is that an abuse of discretion for the court to say, no, that's enough. I gave you the chance to respond to the motion to dismiss. You didn't come up with the 18 documents, exhibits at that point, but you waited and then gave them to me several weeks, months later. I don't know how long it took. But we follow that. I mean, why, as an appellate court, would we second guess that decision from the Superior Court? That's pure abuse of discretion.
Well, the whole thing was reopened. The judge did consider all that stuff and decided, no, that's not enough.
So she was taken in an abundance of caution, I would have.
As far as the Superior Court judge or
Yeah. Well, I mean, that's her prerogative to say, look, in abundance of caution, I'll take a look at it. But
I think that's great. I mean, the more a judge can
consider. How is it abuse of discretion to say, you know what, I'm sticking by my initial ruling?
Well, because at that point, having all those materials in front, say, this is what you did, this is what I've got to work with. I'm going to decide, I'm going to take this away from the jury, and I think that's a right thing to do because I don't think the jury gets to decide this particular issue under these particular circumstances. But why not? There's a lot of questions there for reasonable jurors to decide.
Is this an accurate summary of your position? That the filing of a motion for reconsideration retroactively transformed the motions to dismiss into motions for summary judgment, even though the motions to dismiss had already been granted?
When you say it that way, it doesn't sound very good. But I would add more nuance to it, though, Your Honor. That effectively, it reopens the question. It allows for reconsideration of the question. And at that point, we have the right to say, well, okay, Judge, you've reconsidered this. We understand your ruling after reconsideration, and we believe it's an abuse of discretion. Because if you had considered all these things, you should have concluded on reconsideration that there are genuine issues of fact here for the jury to decide, and allow the parties to present those facts to the jury. And maybe bring in somebody from the credit card company, for instance, that says, if we had received a subpoena or other court document, our step one is to contact the client. Maybe that's not step one. Maybe they just automatically do it. But maybe they would say step one is to contact the client. Step two is to give the client an opportunity to fight this. And then you get into some interesting questions about, well, what can the client do? If I come into court, if I come into Judge Brown's chambers with a subpoena and says, I want your credit card bills because of an accident. And he'll say to me, I've got them in my hand. I'm not giving them to you. I don't want to incriminate myself. I think he has a right to say, you don't get them. Well, if you have some sort of control over your credit card company as far as what they disclose and don't disclose, isn't that the same thing as having the records physically in your hand? And if you have that, isn't it a violation of the Fifth Amendment if to have a court demand that you turn those over when you are saying, no, I've got a Fifth Amendment right, these things may tend to incriminate me? Now, my colleagues across the aisle have this argument that says, well, it wouldn't have mattered. These credit card bills had nothing to do with the criminal prosecutions for this horrible driving, endangerment, and all these other bad things that injured these police officers.
Isn't that true?
No.
Well, what does it matter if you get the alcohol from Circle K or Walmart or the bar?
Well, Circle K or Walmart doesn't matter, unfortunately, under our dram shop system. You can buy whatever you want there, and you're not going to be held liable.
I'm talking about the criminal liability.
How
did it change the criminal liability? Did it make him liable for that it became worse?
Well, maybe.
The fact that he drank at a bar as opposed to drinking on the side of the road?
Maybe. Consider this scenario. Suppose they get video from the bar and sound and video, and it says, well, Mr. Mukaj, we're gonna order you an Uber. I can drive just fine. Oh, Mr. Mukaj, we're gonna take your keys and we're gonna drive you home to your place of lodging, and we'll give you the keys back then after we park the car safely and make sure I'm not gonna do that. Or if it says, well, Mr. Bacage is bragging that he can drink and never has bad driving. Wouldn't those things tend to enhance what he did, make it even worse than it was? It might. And if so, the Fifth Amendment is a protection for him from that sort of thing. He doesn't remember what he did, but it could have been something pretty horrendously bad, and it's pretty smart on the part of his lawyer to say, I'm putting a clamp on all this stuff for my client and through his client, and you're not going to get anything until this whole thing is resolved as far as the criminal aspect of it.
Did you want to address your relation back argument?
I think I did a fairly good job of it in the brief, but Rule 10 seems pretty clear. And I know it wasn't specifically discussed, but isn't it always there? I mean, isn't that really the point of all this? Is there a relation back? And it's one of the more unusual rules. I mean, it just says, if the name of the defendant is unknown to the plaintiff, the defendant may be designated in the pleadings or proceedings by any name. If the defendant's true name is discovered, the pleading or proceeding should be amended accordingly. Well, that sounds pretty good to me. And it doesn't talk about all these other, the embellishments of reasonable diligence. Well, not a very clear-cut, very straightforward rule based on a California rule of all things. We have a lot of precedent on the California rule. And it basically says you have to have a prejudice element in their consideration. That's opening brief, page 45. Page 46, opening brief, page 46. There needs to be a prejudice element, prejudice to the defendant, and there isn't here other than you've got to defend the case. I mean, what the heck? And then the relevant inquiry, the California cases say, are the facts that the plaintiff actually knew when the original complaint was filed. And they didn't actually know about any of this stuff when the original complaint was filed.
But Arizona and the Flynn v. Campbell case focus on what the defendant knew, not what the plaintiff knew. And is there anything in the record that would indicate that the bars here knew that this case had been filed and that but for a mistake they would have been named?
No. And if they did, they'd never tell you. They're the most close-lipped tribe on the planet. If you've been involved in one of these cases as a judge or a lawyer, they don't say anything about anything. If I may reserve my time. Thank you, Your Honor.
Okay. Mr. Giles? Yeah.
Thank you. D. Giles for Defendant Old Fashioned. I'll acknowledge my colleague Derek Warner, who represents Uncle Shady's. I'll take all of the time so you guys can answer me questions or ask me questions. I want to start with two things. This case involves two separate inquiries. The first question is on the motion to dismiss. Did the Superior Court abuse its discretion when it granted the motion to dismiss? The motion to dismiss is based solely on the pleadings that were before it. That is a motion, a joinder, a response to the joinder, and then replies. In those pleadings, other than in the response that the plaintiffs filed, other than a bare allegation that the discovery rule tolls, there's no offer of any evidence whatsoever about any due diligence in investigation, any efforts undertaken, even though that information was available to the plaintiffs and known to the plaintiffs because it was information that their attorneys had gathered over the course of the lawsuit before my defendant and Uncle Shady's were brought into the lawsuit. On a motion to dismiss, you are limited, and the judge was limited to the pleadings that were before her on that motion to dismiss. She considered those pleadings, granted the motion to dismiss because, as she noted, there was no basis for tolling the statute of limitations. It's significant to point out that in the complaint, the First Amendment complaint, there's no allegation of tolling. There's no allegation of any investigation that was undertaken to perform anything to identify the two establishments, even though in the original complaint, the plaintiffs acknowledged, even though they don't have a dram shop claim, a claim asserting that there is some liability for service of alcohol, they acknowledge in that complaint that there is at least the potential for a dram shop liability claim based on Mr. Mukage's intoxication, which was well known to all the parties within days after the accident. The question before this court here on this is, does a one-year statute of limitations get tolled when there's no indication of any efforts by the plaintiffs at any point within that first year to do anything to identify the names of the bars. The first information we have about any efforts that were undertaken by the plaintiffs to learn the names of the bars, learn where Mr. Mukaj had been drinking, was after they filed their original complaint. Even though there was information available that was clearly known to them because it's indicated in their complaint that Mukaj was intoxicated, there was some idea that he had come from out of state and maybe had stayed at a hotel. There was TSP, his employer, was known. There were avenues to pursue in order to gather that information. But the plaintiffs did nothing and then once they begin their investigation after the complaint is filed, they do some things. They ask TSP about it. They ask it for credit card information. TSP says, we don't have any credit card information. And they ask Mukaj, who says, I'm going to plead the fifth on everything. And that's where it ends. From that point, there's no effort undertaken to identify, locate, serve any credit card companies, any other third parties that might have that information. And one thing that is significant is Mukaj says, not only does he say, I'm pleading the fifth, he also, through his attorney says, I don't have any memory of that incident. I don't have any memory of the events leading up to it. So it's known to the plaintiffs that a deposition of Mr. Mukaj is not going to reveal any information unless he changes what he's telling his attorney, because he said the whole time, I don't know anything about where I was. I can't remember anything about the events leading up to it, which tells you that you've got to do something different. You've got to go somewhere else to gather that information. It's not going to be Mr. Mukaj. Could it be his credit card statements? And Mr. Ebney talked about the Fifth Amendment privilege against self-incrimination. And admittedly, Mr. Mukaj did that, and that causes some difficulty. But it doesn't prevent Mr. Mukaj from offering stuff that's not incriminating. And Mr. Mukaj names the bars. He doesn't identify the bars, but he names the bars as non-parties at fault. TSP identifies the bars as non-parties at fault. There's other avenues to pursue to say, look, you have got to provide us information about the identities, which is the only thing that matters at this point in time. It's not how much he drank at the bars. It's not what time he was there, whether he bought chips or something else, which is totally unknown still today, totally unknown. What matters is the identity of the bars, because that's the key information that the plaintiffs need in order to pursue their claims, the name of the bars.
He did not identify the bars in a notice of non-party at fault.
He identified essentially purveyors of alcohol that may have provided him with alcohol without identifying who those bars are.
And when, do you recall when the notice of non-party?
That was in
I'm just roughly, that would have.
December of 2021.
Okay.
November, December of 2021, I believe. Before any information was ever provided. And another significant gap that should have been pursued is going after, and at least, because if you're going to rely on the tolling, you have to show that, the case law is very clear, you have to show some due diligence in your investigation. So at the very least, you have got to be able to show to the court that you did some due diligence in your investigation of the identity of these people. Mr. Mukaj has created a roadblock because he said, I'm pleading the fifth on everything. I'm not going to provide you with anything. But, and this is what the Gallardo, the unpublished Gallardo decision that we cited in our briefing talks about, is you can't just at that point throw your hands up in the air and say, okay, you're pleading the fifth. I don't have any other basis to get this information. When you know information that could lead to it, at least do some efforts to pursue that information through alternative sources. Whether the efforts are fruitful or unfruitful, they may very well have not yielded anything. A credit card company issued a subpoena, very likely would have said, we're not providing you any of that information without Mr. Mukaj agreeing to it. But the effort has been undertaken by the plaintiffs to try and learn that information. And you can also challenge the scope of the Fifth Amendment privilege. As Your Honor was talking about earlier, just because there is a privilege, it only applies to self-incriminating things. The identity of the location where Mr. Mukaj consumed alcohol is not going to incriminate him in any way. It has no relevance to any of the issues in the claims that are asserted against him for aggravated DUI, for endangerment. All of those relate to him driving in the vehicle while he's intoxicated or extremely intoxicated. Next, we have to move to the motion for reconsideration. And that is a totally different standard, different standard of review. It's an abuse of discretion standard. And Mr. Abney talked about this change, this metamorphosis that happens when on a motion for reconsideration you offer new evidence, that somehow changes the underlying motion to dismiss into a motion for summary judgment. I've located no law that supports that argument. The motion for reconsideration is totally separate and considered separately, and that's what the judge did here. Did she consider the new evidence? It always existing evidence, but it was new to her evidence about what what plaintiffs had done? Yes, she considered that evidence. But that does not transform her motion for reconsideration into a de facto motion for summary judgment, particularly when it is evidence that could and should have been presented in the in the pleadings on the motion to dismiss. Here we have a situation where the plaintiffs deferred to the actions of Mr. Mukaj in asserting his Fifth Amendment privilege and took no other efforts outside of asking for TSP, who they learned fairly early, I think that was within days of filing the lawsuit, that they learned that TSP had no information about where Mr. Mukaj had been that night. And so there was imposed upon them a duty to go into that and investigate further in order to show, because the key inquiry here is not what the court would have done again, but whether or not the plaintiffs themselves showed due diligence in investigating the identity of these bars. I want to talk a little bit about the 10D relation back argument. First of all, I think that's been waived because it was never raised in the trial court. The first time it was raised is on appeal. And even if it did apply here, it doesn't apply in this case because the relation back assumes that you name, and I think Gallardo maybe would be a good example. In Gallardo, they actually did assert dram shop claims against the unknown, unidentified bars. Here, other than that one allegation in paragraph 8 of the complaint, the original complaint, there's absolutely no allegation of any dram shop case, statutory, common law. Because this case is barred by the statute of limitations and there was no effort to do their due diligence in identifying the bars, the court acted properly when it granted the motion to dismiss. It acted properly when it affirmed itself and denied the motion for reconsideration. And unless you have other questions, I won't take any more of your time.
Questions? No. Thank you, counsel.
Sorry, I was expecting a tag team. I usually get that, but very few points, a few points. Any identification of the bars was done, non-parties at fault, by the employer, who was briefly in the case. As far as efforts at due diligence, there was they secured the insurance company investigation and reviewed that. They secured the state investigation and reviewed that, the police reports. They took a deposition of the employer and made inquiries of the counsel for Eldorado Mukaj. Whether that's enough, I would submit, would be something for reasonable jurors to decide. My colleague, I believe, said something to the effect that the credit card company would have likely refused to provide cardholder information without notification, at least, or something to that effect, which is fair and probably would have been more resistant than that. Even we don't know. That's a question for the jury to decide. As far as relation back, whether Rule 10D is on the table or not, we're really, more than anything, talking about the discovery rule. When should these plaintiffs have discovered, or with the exercise of reasonable diligence, when should they have discovered that they had some sort of a dram shop claim? And that really is setting aside any relation back sort of theorizing. That really is a question of fact. in case after case, and in this case in particular, what they could have known if they had done this, that, or the other. Should they have done this, that, or the other? Those are really questions for the jurors to decide based on their common sense and based on what they hear in court about what happens if you take step A, go to the credit card company, or take step B, go to the car company, or go to the hotel. What sort of information are you going to get, and then what can you do with it? I think that's pretty much it. If I can generate goodwill by giving my time back, I shall do that.
Okay, thank you.
Thank you, Your Honor.
Okay. Thank you both, counsel, both of you for your arguments this morning. This matter is under advisement, and we'll issue a decision in due course. The court stands in recess to prepare for the next argument. Thank you.